everyone. I think we're about to start. So welcome back. It's been a long day, so thanks for bearing with us. And welcome to the third and final panel. We have quite a few great speakers. So basically, the way it's going to unfold is that Nimer is going to go first, then Mai, and Barb Jackman could not make it, so she sent her the partner from Jackman and Nizami and Associates, Harriet Nizami, who will be presenting her paper, and then the discussants. And my name is Sujith Xavier, and I'm not going to take much time in terms of the introductions. Nimer, I think all the bios are in the program, so I'm not going to bore you with everyone's details. So Nimer, if you want to start off, that'll be great. Thanks.
Sure, thank you. So thank you for the organizers and for the inviting us. So I was asked to speak about the effects of the Arab Spring on the question of Palestine. And examining such a question requires attention to both external geopolitical factors and also internal factors. So I'll mention in a fleeting way the external geopolitical factors and focus on the internal factors, namely what I call the counter-democratization processes in Israel-Palestine. And I will treat it as one entity, that is as a one state, not for the standard arguments that there are so many settlers and settlements and it's irreversible and therefore it's one state, but for given the existence of two processes that I will try to outline quite briefly. One is the process of Bantustanization, and the other is a process of ghettoization inside Israel itself vis-a-vis the Palestinian minority. So I'll try to show it's a one state, and it's an increasingly undemocratic one. And in order to understand that, and in order to understand how these two processes parallel each other, we need to get rid of the compartmentalization, that is, the ways in which we think in compartments. I think legal and political discourse pushes us to think in compartments, in different legal categories. So the Palestinians inside the West Bank and Gaza are protected persons according to international law, and they have different sets of rules and laws that govern their interaction with Israel and the management of their daily life, the Palestinian daily life. The Palestinians inside Israel are citizens, and they have different sets of rules within domestic law and international law that govern the interaction with the Israeli state. The refugees are a different category. And so these are different categories in which the Palestinian body politic is divided into, and they are supposedly different. So I think we need to see more the similarities. So the more I think about this, the more I write about this, the more I see the similarities, at least between the Palestinians inside Israel and the Palestinians in the West Bank and Gaza. And I want to emphasize these rather than the differences, which are, at the end of the day, differences in degree rather than kind. So perhaps this is one way to understand revolution without seeking to define it, as the gentleman in the morning remarked about why we are calling this revolution. If you look at the history of the West, you will find that the Glorious Revolution was just replacing one king in England with another, and yet it was called the Glorious Revolution. The Industrial Revolution is also a revolution. So, it's a rhetorical move, and it's an essentially contested concept, so pick your definition. So I will not try to define revolution. I will not try to exclude certain definitions. I'm only trying to argue that one way of understanding its ramifications is to think of revolution as an attempt to at a paradigm shift in a sense of overcoming compartmentalization in the case of the Palestinians. So let me say a couple of things about the external factors. Although the dust has not settled yet, so there is a sense of a risk in making an assessment, I think that overall, the Arab Spring is likely to contribute to the already existing process of the decline of US-Israeli domination in the region. So previous factors for this decline include the rise of Turkey as a regional power whose interests are not always in line with the US and Israeli interest, the colossal failure of the American occupation of Iraq, and the increase of the rise of the Iranian role in Iraq. And thirdly, the rise of non-state actors, armed non-state actors who can withstand a long war with a conventional army without being annihilated. Now, the Arab Spring promises to exacerbate these processes and to provide us with a new regional order. To begin with, Arab authoritarian regimes has most of the time been had a bad effect on the Palestinian Revolution, or the PLO as a representative of the revolutionary movement since at least the beginning of the 60s. So in the 70s and the 80s, Syria, Libya, Iraq, you name it, had a front, a Palestinian organization. They funded and they encouraged Palestinian factionalism. Jordan competed with the PLO over representing the West Bank and its interest, and Jordan, as well as Morocco, had long-standing secret ties with the Israelis. And Egypt under Mubarak, as we all know, has been part and parcel of the siege on Gaza. And the Arab reaction to the latest Israeli attack on Gaza half a year ago might be an indication how things might look differently in the future, in the sense that many Arab ministers have entered Gaza during the attack, and President Morsi of Egypt was credited with mediating the ceasefire. Now, the demise of these Arab authoritarian regimes is a good thing, I think, because it allows more space for democratically elected government to be pressured by the popular sentiments, which are more pro-Palestinian than the previous ruling elites and the authoritarian regimes. And the instability that democracies bring, as we see now unfolding before our eyes in Egypt, I think might make it more expensive and more difficult for Israel to maintain its oppressive regime. Now, the main difficulty, of course, is that the Gulf sheikdoms, the Gulf states, and the counter-revolutionary role that mainly Saudi Arabia play. It might be the case, as Marx and Engels discovered during and after 1848, that without a revolution in Russia, given the counter-revolutionary role that Russia played in Europe, there is no hope for a successful revolution in Europe. And it might be the same with Saudi Arabia. Okay, let me move now to internal factors. So internal factors can be either popular reactions or formal processes. Popular reactions, we've seen mainly two reactions, one inside Israel, which is the social protests in the summer of 2011, and the second in the PA-controlled territories, which is the demonstrations against Fayyad in August and September 2012. And I think these two processes mimic each other and mimic what Richard Falk called the, following Ghunaim, the apolitical aspect of protest. And I think the same reason that allowed the success of these protests is the same reason that guaranteed their failure, which is the depoliticized character of these protests, because it guaranteed that they will have no effect at all on the formal process of decision-making in either the Israeli power structure or the Palestinian power structure. The Israeli protest ignored the impact of occupation on the living expenses and distribution of resources inside Israel. The Palestinian protests against Salam Fayyad's government and economic policies actually reproduced the same paradigm that they criticized, which is the depoliticization of the state-building process, according to Fayyad. So their depoliticized character basically was playing in the same playing field. Now, there was another episode, which is an unfulfilled opportunity to mobilize Palestinian refugee communities in March 2011, I think, when the return march was organized, and then it was met with lethal Israeli force on the borders. But that did not evolve into something more consequential. So let me move now to the formal processes. The current Western approaches to the both Israel and Palestine impede democratization in both entities, in the same way that they impeded democracy in the Arab world in places like Tunisia and Egypt by supporting non-democratic actors. So let me start with the PA. The US, Canada, the EU are funding a large security apparatus in the PA, and they are training it and they are funding it with the help, of course, of Egypt, of Jordan, and before that, the Egypt under Mubarak. And a fleeting, if you skim one of the human rights reports of the Palestinian human rights organizations, you can see what is the modus operandi of the PA in these territories, whether it's torture and degrading treatment, violation of free speech rights, of peaceful assembly, of freedom of association, etc. So this is the kind of police state that the Tunisians revolted against, and corruption is rampant in the same way that it was in Tunisia. And even procedurally, this Western-backed PA is not democratically legitimate because the term of the president has expired in January 2009. No elections for the Legislative Council has been scheduled since January 2006, in which Hamas won, and the Palestinian National Council of the PLO is an antiquated and marginalized body. And the PLO Executive Committee does not include many Islamist organizations like Hamas. So basically, virtually all the Palestinian institutions are non-representative. Now, Canada, the US, and the EU are basically reproducing the same paradigm that governed their interaction with the previous regimes in the Arab world, which is preferring secular dictators over the possibility that a democratic process will bring the Islamists to power. So one European official told The Economist in April 2010, I quote, "The last thing many in Europe want is for Hamas to regain an executive role in the West Bank. We prefer division and no elections to reconciliation and elections." But now we know that the Western powers are talking to the Islamists in Egypt. Will they talk to the Islamists in Gaza? Now, the PA, against the backdrop of the democratization processes in the Arab world, their main policy was to apply for a UN membership and statehood. Now, which of course, replicates what Arafat did in 1999. If you recall, the end of the interim phase, the Oslo interim phase, Arafat declared that he will declare a state, and then we had also the same prime minister on the Israeli side, and with the same reaction, and Arafat was doing basically the same thing that Abu Mazen replicated 10 years later. So this brings to mind what Marx said in the first paragraph of the 18th Brumaire of Louis Napoleon, which is history repeats itself twice, once as tragedy and the second as a farce, Arafat being the tragedy and Abu Mazen being the farce. So here the attempt in these applications to statehood and membership is to legitimate the PA, given the fact that they failed to achieve anything substantial during years and years of negotiations. In fact, it provided a cover for a colonization process by the Israelis. And to legitimate the PA in a way that is without recourse to democratic legitimation or revolutionary legitimation. So if you recall, before in the 70s and the 80s, when the PLO was speaking about the legitimacy, they thought that, or they declared that, revolution is what the sacrifice for the homeland is what provides them legitimacy. Now the Arab Spring is saying that democratic legitimation is the source for legitimacy. But the way out of this, not going to for elections or democratizing the PA institutions, and without resort to any crisis that would endanger the benefits that they got from the current structure and their being integral part of it, without endangering their status, is to go to the UN. Now, this is basically a flight to law. It's a flight both from democratization and from revolution. Now compare this to Namibia. We talked earlier about Rhodesia. Let's look now about Namibia. Namibia, despite the fact that Namibia, to recall, was occupied by the South African apartheid for about 75 years. And they had about 4 favorable advisory opinions by the ICJ in the end of the 60s and the beginning of the 70s. And yet, SWAPO, the Southwest Africa People's Organization, declared an armed struggle, despite these advisory opinions, against the South African occupation. And later on, the General Assembly of the United Nations recognized the right of Namibians to armed struggle and required that other states to assist them in any way, including military assistance. So the difference between the Namibian case and the Palestinian case seems to be an opposite track of struggle. The Namibians moved from law to revolution, from advisory opinions to armed struggle. The Palestinians moved from revolution to law, from armed struggle and 2 intifadas to an advisory opinion in the UN, and then formal applications for statehood and membership. So Namibians gained their statehood after liberation and independence. The Palestinians are seeking their statehood before liberation and independence, which shows that there is a fetishism of statehood on the part of the Palestinians, which will only lead to the illusion of sovereignty and parity with Israel. Let me move now quickly to Israel. So one way to understand revolution is through the literature of transitional justice, which is a kind of a legalized mode or a legalized form of a revolution in which you are trying to capture different transitions at different moments. So there are 3 ways on a temporal line to understand transitions. One is a transition within an ordinary constitutional law without any change in the regime. So Canada, for example, in the Mabo case, in which the court declared that the previous legislative and judicial history of depriving and dispossessing the indigenous people from their lands is an unutterable history of shame. That has not been the case in Israel. A second one is actually what they called it a constitutional revolution, which gives us another sense of revolution, which is a rhetorical exercise of using the word in order to conceal the fact that there are no genuine revolutionary processes on the ground. A second one is constitution making as part of a transition, which what happened in the South Africa. This also wasn't the case. Another one is to produce a constitution after the collapse of the regime and within a process of constructing a new regime. This hasn't been also the case in Israel. Now, bringing the Israeli case also reminds us that, unlike everything that has been said since the morning, revolution is not an unqualified good. We have been talking about revolution as a good thing, and faith in revolution is a good thing, but revolutions can be also a bad thing. Revolution can be motivated or initiated by bad actors. So Zionists talk about themselves, about the Zionist project as a revolution, and in many senses it's a revolution. It revived the Hebrew language, modern Hebrew language. It created a nation out of an exilic, diasporic communities who spoke different languages and lived in different nations and so on. So this is also one way of understanding a revolution. Now, quickly, why there is a process of ghettoization inside Israel? The Palestinians inside Israel are 18% of the population, and yet they are 50% of the criminal prisoners, they are 67% of the murder suspects, and they are 70% of the attempted murder suspects. There are 54% of the Palestinian families inside Israel are poor, 65.8% of the Palestinian children inside Israel are poor, more than 90% of the Palestinians live inside their own segregated communities, more than 99% of the Palestinians inside Israel study in their own schools, and there are many, I don't have the time to talk about all the legislative and the judicial infrastructure that have been created all over the years in order to maintain this segregation. And so basically what happened is that the state in Israel produced concentrated poverty in racially segregated areas and prevented social and spatial mobility. This led to transforming these Arab communities into areas of high crime, poor schools, high mortality rates, and welfare-dependent residents. In other words, they became ghettos. Now, this process of ghettoization corresponds to a process of Bantustanization in the West Bank and Gaza. And these two processes basically are about separating between the communities and annexing or controlling the land at the same time. So in the occupied territories, Israel basically de facto annexed the West Bank. Israel is controlling, Israeli infrastructure is over more than 59% of the West Bank. Israel have, over the years, invested more than $100 billion, according to one estimate, in the West Bank in a Jewish-only infrastructure. Legally, Israel never recognized its status as an occupying party, and they refused to apply the Geneva Conventions with the exception of the so-called humanitarian provisions. Israel pursued a policy of de-development in order to make the Palestinian communities economically dependent on the Israeli economy. The prolonged nature of the Israeli occupation undermines the international law assumptions about the temporary nature of occupations, and international donors like Canada and the US are basically funding the occupation because most of this funding goes to emergency funding and assistance. Israel, and this is more important, I think, has integrated the West Bank into its legal structure. So one way to see that is in the tax system. So at least since the Abu Afif decision in the beginning of the 80s, the Supreme Court has integrated, it was a case about the value-added tax. The Supreme Court has integrated the occupied territories into the Israeli tax system. In the same way, you can see that in the labor disputes. So the Supreme Court have harmonized labor laws. And you can see that in cases involving Palestinians suing settler corporations in employment contract and tort cases. And this is interesting because it's a reversal of the political. We mostly focus on the political. But if you see in these private law arrangements, you can see that the settlers, for example, who would politically argue that Israeli law should be applied and Israeli sovereignty should be extended to the West Bank and Gaza, in these cases, they argue for the application of Jordanian law because that benefits them. The Palestinians, who would normally argue that Israeli law should not be extended to the West Bank, argue for the application of Israeli law in these cases because that benefits them. Finally, Israel fragmented the West Bank into non-contiguous areas with racially segregated populations, imposing two different sets of laws, two different sets of roads, and more recently, different buses. In other words, Israel created Bantustans. So both inside the Green Line and both in the West Bank, Israel created an apartheid system. So 1 minute, and I'll be done. Now, why is the apartheid analogy is apt? First of all, South Africa was not a totalitarian state. It was a multi-party electoral system with a lively debate. Secondly, the Group Areas Act of 1955 denationalized millions of South Africans and gave them passports and declared them as independent and civil governing entities, which is analogous to my mind to the Oslo process. Thirdly, South African system was not with absolute prohibitions. So the so-called Section 10 blacks were not required to carry passes according to the pass system. Finally, the apartheid system distinguished between those blacks who resided in the Bantustans and blacks who resided in the urban white areas. And after the constitutional reforms in 1983, coloreds and Indians were granted the right to vote, and they were granted political rights and the right to own property and to live in white areas. So basically, the apartheid regime was different oppressive measures against different populations at different times. And I think the same goes for Israel. Thank you.
Let's take this opportunity to thank Nimer. Thanks, Nimer, for staying on time. If you want to, yeah, if you want to go ahead.
Yeah. Okay, so today I'm going to be talking about new forms of resistance in the Egyptian revolution through new assemblages forming out of that rupture. I address their ambiguous relationship to the law and the state, And through snapshot examples, I engage with the seeming contradiction between their lack of commitment to any some kind of form of rule of law ideal and their uses of the law at the same time. So what are those assemblages? First, the term assemblages is borrowed actually from Saskia Sassen. She uses it in a slightly different way, but I took that term from her. It was used by other political theorists, but this is where I got it from. But what I mean here is they are clusters, operate as clusters of resistance. More specifically, they are non-hierarchical, anti-state security, voluntary-based, and action-oriented resistance clusters. So why are they interesting? I think one of the interesting parts of the aspects of them is that they were quite successful at some points during the revolution, and what makes it also interesting is that they challenge the dominant story of revolution, where you have a particular leader or a party that takes over and establishes a new legal order, a new state, a new government, etc. So where does law come in? I think what is quite interesting is their comfort in moving between the use of legal and illegal tactics. And by legal here, I don't mean just merely being sanctioned by the law, but I mean the explicit use of the law and legal institutions. What I also think is particularly interesting about them is that they actually replace some of the state's central functions, such as even policing, maintenance of public transportation. I'll give more specific examples as we go along. So how can we envision the relationship between these new assemblages and the state? And I think one interesting way to look at it is by looking at the relationship between law and violence. And I was particularly influenced by Benjamin's essay on the critique of violence. For Benjamin, clusters that challenge the state's monopoly of violence become a threat, not because of potential triumph of their struggle for power from the state, but merely because they operate outside of the legal state, and therefore challenge the law in itself. So what is precisely Benjamin's point? His point is that all violence as means is either lawmaking or law-preserving violence. Lawmaking violence is that initial violence, that inaugural violence, and the creation of a new legal order, for example, by a Declaration of Independence or a new constitution. Law-preserving violence is rooted in the state's institutions that actually defend that initial lawmaking violence through, for example, notoriously the police, among other institutions of the state. What he argues is that both lawmaking and law-preserving violence are what he calls mythic violence. Why mythic? Because of their internal circular logic, whereby any law-destroying act results in a positing of a new law. So as I mentioned earlier, a new leader comes in, takes over power, and establishes a new constitution and a legal order. How can we escape the circle of mythical legal violence, where their legal violence is recreated again as a rupture takes place? He responds by this idea of divine violence. And again, just to note the language that Benjamin used, he was significantly influenced by Jewish mysticism, and we see traces in this language of profanity and divinity. However, we can still set aside that particular mysticism if we want, and explore further this idea of a bloodless, law-destroying violence in a revolutionary situation, which he defines as divine violence. In fact, divine violence is directly connected to a revolutionary situation. It belongs to the order of the event. One manifestation of the state abolishing, law-destroying, bloodless violence can be sensed, for example, in these new assemblages that replace some of the state's most central functions, and by doing so shake the ground that securely holds the dual force of lawmaking and law-preserving violence. The close affinity between law and violence depicted in Benjamin's essay also appears in the works of Marxist jurist Yevgeny Pashukanis. While Pashukanis is considered one of the leading figures in Marxist legal theory and the first to conceptualize a comprehensive commodity form theory of law, Benjamin, by 1921, had neither read Marx nor Lenin. Nevertheless, like Pashukanis, he saw the fundamentally violent character of law. Pashukanis sees that legal relations by their nature do not presume a condition of peace. The criminal jurisdiction of the bourgeois state, for example, he argues, is organized class terror. And he explains that the only way to grasp the truly antagonistic character, which is clearly manifested in areas such as criminal, the only way to understand the purely antagonistic and punitive character of the class state is by understanding its antagonistic character, which is clearly manifested in areas such as criminal law. The starting point of criminal law proceeds not from the harm done to the victim, but from the violation of a norm created by the state. It is about maintaining the state's power to enact and enforce law, its absolute freedom. And again, these assemblages of resistance forming in Egypt are relevant here. Through their illegal and their legal tactics, they challenge the state's absolute freedom. There's actually a relatively recent legal debate on the question of law, violence, and revolution that took place in a very unlikely space, the 100th anniversary of the creation of the American Society of International Law in 2006. The roundtable discussion comprised of a number of legal scholars, broadly aligned with the tradition of critical legal studies. What was striking about the discussion was the subtle categorization of violence into the hands of that abstract revolution. Nathaniel Berman, for instance, noted the violence that came out of the 1917 Russian Revolution and the decolonization movement. Contrary to others participating in the roundtable, China Mieville asserted that it was precisely the revolutionaries of the Paris Commune, for instance, who refused to execute the hostages taken, which again attests to Benjamin's idea of the bloodless, law-destroying divine violence. However, for China Mieville, he sees this disciplining of violence in a revolution as necessarily channeled by a party. Here I depart from Mieville and use the Egyptian assemblages to argue against a necessarily controlled and hierarchical structure to effectuate nonviolent, or for that matter, even violent revolutionary change, a position that was taken on by a number of scholars, including Middle East historian John Chalcraft, using the concept of horizontalism from the work of Rebecca Solnit and Harta Negri. Are you dizzy yet? Okay, so according to Chalcraft, horizontalism is decentralized or networked form of organizing, leaderless protest movements, the SQL of top-down command, the deliberative rather than representative democracy, the emphasis on participation, creativity, consensus, the opposition to dogma and sectarianism. Horizontalism, he argues, has close affinities with the idea of the direct democracy, where democracy is not understood as what activist Amr Izzat has sarcastically called boxocratic, where the ballot box or the democracy is reduced to the ballot box. Democracy is understood by these assemblages as self-managed and unmediated governance. The assemblage's democratic structure has been part of their success, as Chalcraft, following Alexandria-based activist Ali Al-Ragel, argues. The former regime was defeated because it only knew how to break down the tree structure, which is vertical. It just cut down the tree or cut off the head of the leader. But a rhizomatic structure cannot be broken down. If you rupture one area, it just picks up in another area. So, what are the examples of these assemblages that I've been talking about? One of the most kind of famous of those examples is the neighborhood committees. And if some of you remember, during the 18-day uprising, the police withdrew from the streets in Egypt, and there were a few days of chaos and a lot of looting, etc. And this is where the neighborhood committees started forming across the cities and the villages. And again, they were voluntary-based, initially non-hierarchical and democratic. And they did not simply operate as neighborhood watch. After the army stepped in, some of them dissolved. However, others stayed. And of those that stayed, some actually were legalized or like kind of negotiated the legalization with the state as to become NGOs, which certainly gives them a very different kind of direction from the others who chose to remain as more democratic maintain a more democratic structure, taking over some of the state's central functions. Example, the maintenance of public transportation. And that particular example happened about a month ago, where the neighborhood committee ended up intervening in their neighborhood's train station because the train tracks weren't being maintained, as a striking worker was absent because of the state's failure to provide good working conditions. And so they actually intervened to fix the train tracks, which is obviously something that one would generally, think that the state would do, as opposed to volunteers from the neighborhood. So one manifestation of these assemblages, which is actually happening right now, is Port Said's self-management. Of course, there's a lot to say about Port Said. It's actually a very complex situation. However, I'll just give a brief context of what's happening there. As some of you might know, last year there was, in February 2012, when Egypt was still under the Supreme Council of the Armed Forces, Alnasseri soccer team of Port Said played against the Cairo team of Al-Ahli in Port Said, and Al-Nasseri supporters, after the game, armed with small weapons, invaded the pitch and attacked Al-Ahli fans, most of them from the ultras. This carnage ended in the death of 72 Al-Ahli supporters and the injury of hundreds more. Live coverage showed the state security's deliberate negligence in stopping the violence. Actually, only 2 months ago, and it was actually just confirmed last week, the court announced that 21 Port Saidis were sentenced to death as a result of last year's massacres. This in turn led to a citywide outrage at the court's death sentence and marked a significant transformation in Port Saidi politics of resistance to the state. President Morsi declared states of emergency in the canal cities and imposed a curfew, which was defied by the people of Port Said. And they actually started a civil disobedience to the degree that now it's almost self-managed by the people. The neighborhood popular committees reappeared in Port Said and took over some of the state's main functions. One example is that during the protests against the death sentences, actually more than 20 people died as a result of clashes with the security forces. Consequently, the Port Saidis organized a people's police, or Najdat al-Shab, composed mostly of striking workers to replace the state's violent security forces, which was responsible for the death of many young activists. As a result, the state's police was forced to relinquish its presence in Port Said. Another example is that many Port Saidis are refusing to send their children to the state's schools, so the neighborhood committees, along with a group of teachers, are starting a free school in Port Said's main square that would be centered on ideas of social justice and the principles of the Egyptian Revolution. Again, Port Said's experiment of self-management is a wider application of the principles of these assemblages forming in Egypt as non-hierarchical and voluntary-based and action-oriented resistance clusters, and especially taking over some of the state's most important functions. One caveat with Port Said is there's a lot of talk about their call for army rule, etc., which is something that we can talk about later. Another example, which is actually unlikely partner with these other examples, is trade unions. And I'm particularly, however, talking about independent trade unions. There's a lot of context behind that, and again, we can talk later about it, but to cut a long story short, 4 independent trade unions announced the creation of the Egyptian Federation of Independent Trade Unions in January 2011 as protesters were occupying Tahrir Square. Now, 2 years later, there are 1,000 independent trade unions. And of course, this is really significant because historically it was only the states' union that completely controlled by the state since 1956. And what is interesting about them is that they were created by the efforts of autonomous workers' committees, which actually became the independent trade unions. And for the purposes of this talk, yeah, I'll try. What's significant is that they are expressly illegal under Egyptian law, and they still are illegal under Egyptian law, which actually makes their relationship to the state very complicated. However, while they're expressly illegal under Egyptian law, they still use the law to put forward the demands of their movement. So, for example, in an interview I did with Jano Sharbel, who's one of the activists on the trade union movement and a blogger in Egypt, he said that one of their main demands, the main demands of this movement, is reform of the trade union law, which is interesting given their actual illegal situation. Even something like the Center for Trade Union and Workers' Services explicitly, which is the reason why I'm saying even, is that because they're usually a bottom-up kind of, they use a bottom-up kind of organizing as opposed to like a top-down. And so they explicitly seek the ILO, and they reference the ILO conventions, which Egypt has ratified about five decades ago. They also use the legal system to defend trade union activists, particularly independent trade union activists that are targeted by the state. For example, just recently, 2 workers were sentenced to 3 years in prison for instigating strikes, sabotage, and obstructing operations. And again, the independent trade union movement was very explicit in the uses of the law to defend the movement and the activists of the movement. Okay, I hope this works. There's a short video. I can skip the video if there's no time. Okay, just a quick context. This group called Operation Anti-Sexual Harassment, or Op Anti-Sexual Harassment, they formed in November 2012 as a result of gang rapes and group sexual assaults taking place in Tahrir Square demonstrations. And perhaps I'll show like a minute of the video to give you a context, but just as a disclaimer, it's a little bit disturbing, so if you will not be comfortable, you can come back in a minute, or I can just not show it. Anyone wants me to not show it? Okay. Okay, I hope this works.
Specifically again. Increased attacks signaling out female protesters exploded over the past 2 years, culminating in scenes like this on January 25th last month. Volunteers and activists of anti-harassment campaigns filmed these mob attacks against women this past January 25th. Some of them were their fellow volunteers. Here, one woman tries to comfort her infant daughter as a mob moves in. Inside these mobs, over a dozen women were gang raped, relentlessly groped, stripped naked of their clothes, and assaulted with knives and iron rods. In one case, a 19-year-old girl was rushed to emergency surgery with large gashes to her genitalia. Such savagery has provoked women to arm themselves, brandishing their weapons during this march as a clear warning to the attackers.
Okay, so this is pretty much the context of Operation Anti-Sexual Harassment. What the group is about is it's basically a group of volunteer activists or non-activists, just a group of volunteers who came together to take over one of the state's most central functions, which is policing the state, which is policing the demonstrations. And what they did was they wore white t-shirts saying against harassment and a square safe for all in order to be identifiable to the public, and they were divided into these teams, basically. And I just skipped that because I'm almost out of time, but you can see them over there. So again, this group assumes this non-hierarchical structure, no leader, volunteer-based, and democratic, and certainly action-oriented form. Other assemblages that is part of my paper, but I won't talk about today, is the group called No Military Trials for Civilians, the Ultras who were implicated in the Port Said incident, and the Black Bloc who are explicitly, their agenda is explicitly to challenge the state's monopoly of violence. So finally, these new assemblages see law as merely one tool through which they can renegotiate and restructure the state's relationship with the people. They use both legal and extra-legal tactics, operate, and they see them as equally legitimate forms of resistance with no particular fidelity to some rule of law idea. They're able to replace some of the state's central functions, such as management of public transportation, policing, monopoly of violence, through their law-destroying resistance. Part of the purpose of this project was to connect these assemblages together through engaging with questions of agency, of resistance to the state and its legal violence, and also to engage with what is usually seen as a contradiction between the lack of an ideal commitment to some form of rule of law and the continued uses of the law. It's often difficult to talk about the relationship between law and revolution, especially when the dominant narrative is the idea that law ends the violence of revolutionary action. The purpose of this paper was to invert this relationship and see law as violence in its origin and functioning. And finally, there is a place for law. What I see as the law's emancipatory potential lies in understanding its structural limitations, whilst grabbing onto its use as a tactic to push forward the demands of the movement. And I think this is an approach that enables the legal left to intervene in a revolutionary situation. Thank you.
As Sujith said, I'm actually here on behalf of Barbara Jackman. She wanted me to apologize, unfortunately, just due to the nature of the work. This happens sometimes. What she really wanted to talk to you about, and the good thing is it's one of the topics that I've actually been working with her for the past 10 years. So I'll just go through the notes and the notes she's handed me. I understand there will be a paper as well. I'm not sure if she is going to write a paper, but I thought that was coming later. In any event, so the issue was the impact of the so-called Arab Spring on some of the cases that we are dealing with in Canada right now, the legal cases, the national security cases, and also the ones where Canadian individuals were tortured in Syria and Egypt. There are two, the most important part of this, of course, is the information sharing between Canada and other states, the degree of relationship when it comes to sharing information. The two types of cases, we've known that Canada's always shared information with other countries, but what actually became quite apparent to us, and the degree of which became apparent to us in two types of cases that we were dealing with in Canada. One of those types are the cases where a security certificate is issued against an individual for on the basis that the individual is a terrorist or an extremist. And the second type of case where the issue became apparent was the Canadian individuals who were rendered to Egypt and Syria and were tortured. In the security certificate cases, there are two two individuals that are nationals of Egypt. And in those cases, what you see is information flowing not from Canada to Egypt, but information coming from Egypt to Canada. One of them, Mr. Jabala, for example, he was issued a security certificate in 1999. Barbara went to court, and after the court quashed it, in the same year, the CSIS then came up with an Interpol notice that, yes, Mr. Jabala he's wanted in Egypt for being a terrorist and for engaging in extremist type behavior. So, and of course, this information would not be shared with Mr. Jabala, and it hasn't been shared with him now. There was some vague description of the Interpol, and that's all he could get in through the summary of disclosure. In any event, but it was convenient that right after the court quashed the decision, CSIS suddenly came up with something that Egypt had provided to Canada, that in fact he was wanted for terrorism charges. And he and his wife had in fact fled Egypt because of the persecution they were facing. In any event, in 2008, the Supreme Court's ruling on the issue actually was helpful in the sense that it allowed at least a part of the information to be disclosed to these individuals. The second type of case in which the relationship between Canada and these countries is apparent in terms of information sharing is the case of Maher Arar and Mr. Almaty, Mr. Moyad, Nuruddin Moyad, and then there's Al-Malki as well. Now, two of these individuals, Barbara and I actually represent. There was an inquiry similar to the inquiry, Arar inquiry, where it was decided that in fact Canada was complicit in his torture, and there was a settlement. The other two cases that we were involved in too were the subject of an inquiry. It's called the Yakabuchi inquiry. Yakabuchi being one of the justices of the Supreme Court of Canada, who's now retired. In any event, as limited as that inquiry was, nonetheless, we found out through there that in fact there was a lot of information sharing between Canada and Egypt, as well as Syria. But this time, it was the reverse type of so as opposed to getting information from them, Canada was sending information to them, either directly or indirectly. That in both inquiries, also in Yakabuchi's inquiry, it was determined that Canadian sending information and unfounded allegations to the Syrian and the Egyptian officials was one of the causes of their torture. And so they are in court. Those cases haven't disappeared. All the three individuals, Al-Malki, Al-Mati, and Mr. Moyad, have sued the government because of Canada's role in their torture. And obviously, what is happening in Egypt and Syria is extremely important to us. At the beginning, there was a lot of optimism because we assumed, that we had hoped that after the revolution, there will be some information coming to us in terms of whether, I mean, the individuals were found to have been tortured. There's no question about it. In terms of all the work that was done by both of the inquiries and the number of experts that were involved in assessing the situation, but we wanted to know the extent of Canada's relationship in both circumstances in terms of what exactly happened. The hope was that the documents will be disclosed, or that the new government, whoever is in charge, might either say, well, this happened or didn't happen, or whatever information we could get. But that hope is unfortunately, I mean, we're still hoping that we'll get something, but given what has happened in terms of the security apparatus in Egypt, I think had, for example, a new form of government taken place, one that would be obviously not subject to the current security apparatus, then the situation would have been different. But it's clear, it was clear, at least to us anyways, that there were careful calculations, political calculations by Western countries in terms of how they want to get rid of Mubarak and how they want to get rid of Assad as well. I don't think they would desire to have the security apparatus be smashed, and so some of the structures that existed in the past continue to exist. And in that respect, whether we'll get the information we need, it's not known. But it certainly depends on the direction that the revolution will take. So these were, I mean, to put it in the context of the Middle East, obviously, I mean, it's no secret that there's been the policy of containment has existed and will continue to exist depending on where the course of struggle leads to. But in terms of information sharing and the rule of law here, I think what is of serious concern to us is that notwithstanding all of these findings, both, and there were obviously similar cases in the US as well, in public cases where these governments have in one way or another been responsible for torture of individuals or have sanctioned their arrest. For example, Mr. Jabal has spent nearly a decade in jail based on allegations that he has not seen. What will happen now is an open question, but also Canadian government has made it clear from what we understand is that notwithstanding these findings, torture is going to be used, because in 2011, the Minister of National Security and Public Safety and National Security, in fact, sent a directive to CSIS and also subsequent to that to Canada Border Service Agency, saying that you can rely on information obtained by torture. And of course, this directive is contradictory to the terms, to the recommendations that had been made by, especially the O'Connor inquiry. O'Connor inquiry was the only one that was empowered to make recommendations to the government in terms of changing their policies. And some of those recommendations included, for example, placing caveats on the type of information you share with whoever, if it's going to get into the hands of individuals countries that engage in torture. So there would be a few levels of checks and balances before you share information. There would be limits on the amount of information, but also the DFE, the Foreign Ministry, would write reports about all of the countries in which they are engaged in a relationship with. They would issue reports and do their own research and issue reports to different national security agencies in terms of the human rights records of these countries. Like if you're going to share information with Syria, you should have your security agencies know the type of human rights record this government has. And in that respect, if there is any chance that the information would be used to either inflict torture or the information, or that it would lead to an environment where it might require torture to get a particular piece of information for you. For example, in Maher Arar's case, Canada asking for particular information from those governments implied that they obviously had to go torture these individuals to try to extract that information. So all of those checks and balances were supposed to be in place, and of course, use of torture in any way is absolutely barred under international law. But the Canadian government is obviously very openly made it clear that it will continue to use information obtained by torture. So what comes out of Syria and Egypt is going to be extremely important for our purposes, at least legally, because the argument they always use, and notwithstanding all of these findings, is that as long as I think what they really believe is that if we haven't seen the person being tortured, we're not going to believe it, no matter what happens. So, and the hopes we had, the Amnesty International and other NGOs that were involved in these cases, has somehow dissipated, I think, because of the turn of event in Egypt. But these are questions we can't answer in terms of what will happen, what we'll get from them. I think everybody would agree, at least the people we work with, if the people were able to take over these institutions, then under those circumstances, we would have gotten the information we would get, and that would be essential in Canada in terms of better understanding the Canadian laws in this respect. So this is the factual information that Barbara wanted me to share with you in terms of what we've seen or haven't seen. But I'll leave it at that, and I don't know if we have time for questions or answers, but there might be specifics that we can discuss further if you have any questions. Other than that, thank you very much. And again, I apologize for Barbara Jackman and the short notice in terms of switching people.
Thank you, Harriet. Now I'd like to invite the two discussants, Ruba Ali Al-Hassani and Sabah Alnasseri, to comment. Ruba, do you want to go first?
Yeah, I'll go first, and I'll probably be brief. At least that's what I think. It was Nathanson who once said that we must have a look at society and culture at large in order to find the place of law within the total structure. And in the first paper, we heard a lot about the structure used, or the Israeli structure set in place to subject Palestinians to violence, whether it's aggressive violence, physical violence, or poverty, or the ghettoization and bantusization. Anyway, and in the second paper, we saw more of the social structure that was set in place as a result of the revolution in Egypt. In the third paper, we see more of a structure that's already in place and has been in place for quite some time in supposedly democratic country, which we hope wouldn't be engaging in this practice of security certificates, and yet it is taking place. And I sort of have a personal connection to each of the papers because during my childhood, I grew up in a Palestinian neighborhood. And so I'm very familiar with the plight of the Palestinian people. I live with it every single day. The second paper, my sister is married to an Egyptian and lived in Egypt and works with street children. And so I hear a lot about what took place in Egypt during and after the revolution. And with regards to the third paper, I've actually met Maher Arar's wife and Jabal's wife, and just experiencing or going through the experience through their words or through their facial expressions was more than enough for me to learn so much about these cases. And so I'm a very visual person, and I love that there was a Prezi presentation because it helps a lot of people visualize what's going on. And so I have a lot of images that are going through my mind. The recent revolutions in general all are special in the sense that they have given us images that stay with us, that will stay with us for a long while. So, for example, has everyone heard of the Egyptian Spider-Man? There was a man last year who climbed the Israeli embassy and replaced the Israeli flag with an Egyptian flag, and all the protesters were cheering on. And I'm curious to know what the Palestinian people thought of this. Was this a sign of hope for them that, after the removal of the Mubarak regime, will we see more Spider-Mans and vigilantes and people who will, think about taking the law into their hands in a good way as opposed to a bad way? So I'm wondering, what the ideas on the other side of the border, what Palestinians thought of this grand scene that took place. Everyone, it was all over Twitter and Facebook. Everyone was talking about the Egyptian Spider-Man because he actually climbed the building without any aid. And another image that comes to mind with regards to the second paper is the unfortunate image that has stuck to my mind of a female Egyptian protester who was stripped. Her chest was bare, and there were army soldiers who were stepping all over her body. And so that's another image that has stuck with me. And then I guess in the third paper, I don't know if this relates so much, but maybe it's just me who thinks that way. The images that are being used, for example, the mugshot of Jaballah, that's the only image we have seen in the media. And so it doesn't really necessarily portray this good image. There's sort of this Orientalism to it where, it's this aggressive Arab, who's a terrorist. It hasn't given us the chance to see the other side, the humane side of this person who has no idea what the charges are against him, what the evidence is used against him. And I don't know how related this is to the third paper or to the discussion surrounding the third paper, but there was also a Time magazine cover of Mursi, where his features were emphasized in a certain way to portray him like an ape. And when I saw that picture, it didn't come to me as a surprise because we know what Time magazine has done in the past with regards to O.J. Simpson and other features, playing with the images to send forward a strong message. And so I wonder, are these images that we see on this side of the world, what do they tell us about the future relations between this side of the world and the Middle East? What kind of information will be shared if this is the image that we already have of each other? And I should be wrapping up. So just one last thing. 2 days ago, the African Commission handed down a decision that's very significant for women in Egypt. In 2008, 2009, 4 women were sexually assaulted. Pardon? 2005, sorry, thank you. And essentially, they were represented by the Egyptian Initiative for Personal Rights and Inter-Rights at the African Commission. And so long story short, the African Commission handed down a decision essentially on the duty of a state to protect women from violence, and in this case, the Egyptian state to protect women from sexual violence. So the Commission urged Egypt to hold an investigation and punish those found responsible, as well as to amend its laws and bring them in line with the African Charter on Human and People's Rights, which Egypt ratified in 1984. It also called for compensation, a financial compensation to these women, and urged Egypt to ratify Women's Protocol to the African Charter. And in September 2012, the very same Egyptian Initiative for Personal Rights and Inter-Rights has submitted further complaints with regards to the more recent attacks on women in Tahrir Square, and especially the virginity tests practiced on women. And that's it.
Yeah. Oh, it's me. Okay, okay. So, my name is Sabah Alnasseri. I'm not included in this biography, so I teach. I am?
Yes, you are.
Thank you. I came late. I was so.
You're on page 18.
Thank you. Great. Thank you so much. So, rather referring to the single paper, I will give my take on the 3 presentations, the way I understood them, and maybe refer to 2 or 3 problematics. Things need to be discussed. The first thing I would say, I differentiate between the Arab Spring and Arab revolutions. Arab Spring is a geopolitical nomenclature created by the US and European allies, designed for a Western audience through specific infrastructure, ideological, media, but also militaries. I speak of Arab revolution as a genuine popular revolution against corruption, exploitation, imperialist intervention, etc. I think this is very important to differentiate between the 2, because the Arab Spring, just like the term democracy, I will come to this in a minute, it displaces the real issues at stake, which is the social questions. And so when we talk about Arab Spring, we reduce the revolution to some kind of liberal democratic demands, voting freedom of speech, etc. It's fine, but that's not what really the revolution are about. So starting with Nimer, the question is I have in mind, maybe we can discuss, what about looking at the PA as part of the occupation regime? I look at Israel as occupation regime, a structure of permanent and subjugation of other population through ideological, political, economic, territorial, etc. Means, tactics and strategies. So what if looking at the PA as part of the occupation regime? So the question is how to challenge the PA, i.e. the occupation regime, legally on what kind of laws, if it's possible to challenge it, rather than looking at the two as two different entities. I think one should look at them as one and the same. So coming to the question of democracy and the Arab Spring, what I realize is that what is exported to the Arab Middle East is not democracy, but the crisis of what I've termed Cold War democracy. Western power, Western Europe and the United States and Canada are going through an organic structural crisis, economically, politically, ideologically, but also a crisis of democracy, of representation, of legitimacy, etc. So what is exported to the Arab world, to Iraq, and try to impose on Egypt, on Libya, and Tunisia, and so on, not democracy, but the crisis of this Cold War, what I term Cold War democracy. Look at the Muslim Brothers in Egypt, and now in Tunis, Al-Dawa in Iraq, and so on. So that's, as I said, an effective way to displace the social question, the question of self-determinations, national and international law. And what we are witnessing, I think, since the 1990s, now exacerbated by the Arab Revolution, is a global attempt to dismantle the old institutionalized form of law, nationally and internationally, and creating a new law qua fait accompli. Occupy Iraq and let the United Nations justify a posteriori the occupation. So we're witnessing here a double strategy of dismantling of old institutionalized form and creation of a new form of law and legalities, and determine the framework within which things can be discussed and resisted legally or illegally. So that's a really dangerous thing. I will connect this to the so-called war of terror. And there is no mistake here. It's not war on terror. It's a war of terror. So 3 minutes. Oh my God. Okay. So I have to be very quick here. Okay. So now I'll just move to the. Okay. I think that why it's problematic on two different levels. I'll come to the second level in a second. I hope I have 3 minutes. Okay, in 10 seconds. So on the first level, I think that law is incompatible with the question of social justice, equality, etc., not due to its discursive indeterminacy, but I think rather due to threefold overdetermination, as Louis Althusser would say: political power, private property, and patriarchy, thus sexual harassment. So the trick is to look at law as an abstract discourse. It's precisely through this mechanism all the essential question of societies and political power are excluded outside the domain of the law. It's not its indeterminacy, it's because of overdetermined character in the sense of political power, private property, and patriarchy. So it's interesting now in this context to see how, and May, she was talking about this tactic, basically to act within the law, yet against the law. But the problem is this: it reminds me of Kifaya, the social movement in 2004 in Egypt. It's precisely defined its tactic as within but against the law. And thus, it was a defensive mechanism. It put self-limitation on the movement and thus led to the failure of the movement. So what I think is this horizontalism, though it's necessary, but I think it's due to the circumstances. That's good, 2 minutes is fine. I think it's due to the circumstances, but I think this is not the appropriate and the most effective form of resistance when it comes to the question of state power and imperialist intervention. I think we need a different form of political organization that can seriously challenge this question of power at the domestic and international level. And again, now, I think it's very interesting. Now, the last 2 points within these 2 minutes. Again, when we go back to Benjamin and Pashokin's. Okay, so Benjamin, when we talk about the making of law, I will keep the preserving of law outside, because what we're witnessing a dismantling of the old law and the making of the law of a new world order. Yeah, so when we take this, the making of the law qua violence, and we take the Pashokin's definition of the justification as the state bourgeois form of organized terror, as state terror, we will end up with these 2 forms of atrocity you are witnessing today. The first one is the so-called global war of terror, defined as global war on terror, but it's global war of terror. And the second moment is the crisis of the state, because what we are witnessing in Egypt, Tunisia, etc., is not a stable political regime and well-defined state. What we are witnessing today is the crumbling of the state and state apparatus, which make it so difficult to operate within and against the law. That means what we need to think about is a different form of legality, possible of challenging the institutionalized bourgeois law in these states and the so-called legalities of the global war of terror. Because this construction of the legality of the global war of terror, 10 seconds, okay, is nothing but what I have once termed logically constructing nonsense. And precisely because it's logically constructed nonsense, it functions very well, because you can apply it anytime, anywhere, against any human beings to silence all possible forms of resistance and challenge. Thus, the global war of terror, Arab revolutions, on the one hand, what happens in Canada here, the surveillance, profiling, institutionalized racism are not 2 different forms, they are one and the same. And I think that's why what we need is an international, transnational form challenging these legalities, the question of political power, open up space for different forms of resistance. I am good in time? Yes. Thank you very much.
Thank you.
So,
I'd like to open the floor for questions. We have about 15 minutes. If you want to go to the mic, please.
All right, so I have 2 questions, one for May and one for Nimer. So the one for May is, I really like your idea of the assemblages, but my problem with it is it makes no distinction in the way you've defined it and presented it between good assemblages and bad assemblages. And in revolutionary situations, especially in transitions, the state authority is imploding before our eyes. All kinds of groupings come to the fore and take over law-making activities and self-rule, etc., etc. Some of them good, some of them bad. In other words, there's no way to tell the difference between the good unions and the bad baltagia, between the rapists themselves, who completely fit your definition of an assemblage. They're horizontal, they have no hierarchy, they're very democratic, and they're making the law, right? And the sexual harassment. So you really need to work it out. And I worry because it has political implications, because it has a resonance of an idealization of anything outside the state that really worries me on political grounds. And so I think you need, if you claim to be coming from the left, right? For Nimer, your outline was very helpful in terms of describing the objective situation of the Palestinians, but I think there's another piece that's missing, which is the subjective situation of the Palestinians, the Palestinian consciousness about revolution. And I think that one of our clues into that has been the Palestinian attitude towards the Syrian revolution. And I think that's absolutely crucial in the story of why revolution didn't get to come to the Palestinians. What does it tell us? That practically the Palestinian population was split in the middle over the Syrian revolution. That a good half of Palestinians remained supportive of the Bashar al-Assad, even though it seems to me that their confrontation with Israel on revolutionary grounds, if it ever happens, stands in absolute parallel to the Syrian revolution and its confrontation with Bashar al-Assad, because what Bashar did is exactly the kind of violence that one would expect Israel to do, and that what Bashar is doing, I think, is defining the ceiling of violence that Israel will be capable of inflicting on the Palestinians if such a confrontation took place. And yet, for many of us who support the Syrian revolution, the debilitating observation of the split of a Palestinian population on the question, I think for me tells volumes about the subjective state of mind of the Palestinians' rare revolutions.
I'm going to give the panelists maybe 3 minutes each or 2 minutes each to respond.
Actually, thanks for your question, because this has actually been a debate between me and a few friends for a few years, even before the revolution, and it came out in the context of the idea of social movements, and we're bringing up, well, the Tea Party is a social movement, and, you know, so what do we, I mean, not all social movements are great, right? And similarly, in the context of Egypt, there's now Salafi, almost jihadist militias that can have the same structure. And I think the difficult part is to have a principled approach to identify, you know, which assemblages do you see as putting forward the ideas of the revolution. And the way to do that, I think, is not only look at their form, but look at their substance as well. I mean, there's a lot of, you could take this exact form and apply it to fascist organizations. That could also be the case. But I think the key is and what's particular about these assemblages is that, and I talk a little bit about that in my paper, is that their fidelity to the principles of the revolution. And you've invoked Badiou earlier, and this is sort of part of my theoretical structure, in that I use this idea of fidelity to that truth, to that event. And so I think the way to distinguish them is precisely by looking at their substance as well as their form. I think their form is really interesting, but I don't think it's on its own enough.
So I would say a couple of things before about a couple of questions and comments I heard from the discussant. So I was asked, what do I think about Spider-Man? So I don't have a generic position about animated figures, but I would say this. So, of course, I'm not speaking for the Palestinians, I'm speaking for myself, but I would like to see not only symbolic gestures, but I would like to see a long-term planned, rational policies by patriotic Arab states. Only with such an approach could the question of Palestine move forward, and not, you know, I mean, Adil Imam had a movie a few years ago about Sabah al-Imara. What did it do to the question of Palestine? Nothing. So it's nice to see it for, 20 minutes, 30 minutes, and so on. Now, I disagree with 95% of what you said, but I don't have the time to. So I'm a legal scholar, you are a political scientist, so I think I didn't think coming to this panel that I'll be defending the law, especially bourgeois law, but this is exactly what I am doing now, will be doing now. So the law is not inherently progressive nor inherently conservative. Whether the law is conservative or progressive depends on the context in which we operate. It's not necessarily determinate or necessarily indeterminate. It depends on the context in which it operates, and it depends on the kind of legal agents and political agents that operate within the law and their ability to do the necessary work that would produce certain actions that will have purchase in political and legal realities. So private property, I don't know Raif in the morning spoke about, for example, about free market. And I will add now private property. So there is a movement in the law called the legal realists in the 1880s till the 1920s and 30s that proved that all these concepts can be manipulated and interpreted in different ways, some of which are not necessarily possessive capitalist, but distributive and progressive. So I think you should consider the option that even private property can be a redistributive measure. And I would like to invite you to see the South African Constitution, for example, in which there is a specifically redistributive aspect of property and interpretation. Now, that doesn't necessarily mean that it will be applied in a certain way that you and I would like to see, but theoretically, it's optional, and therefore you cannot claim that the law is inherently so and so. Now, the legal challenge to the PA being part of the occupation, of course, part of I was trying to say is the PA part of the occupation, because I was looking at it as a one control system. However, I was trying to say in my, bringing up Namibia and mocking the PA's application to the UN membership and statehood, that it's an illusion to think that the law will produce predictable results, that the law will provide a space that is free from political manipulation and power relations, as opposed to, so it's a flight from politics, and what we need is not flight from politics, but rather a different kind of politics by the Palestinian leadership. Now, as for Lama's question, so it so happens that Raif, who's sitting here, and myself were part of an attempt to contribute to the discussion in the Palestinian community in different media outlets inside and outside Palestine in order to try to change the prevailing conception. Actually, I would say that most of the Palestinians are for the Syrian regime rather than, and the more it becomes prolonged, the more it becomes difficult to. Now, I think it's important to analyze the discursive moves that the proponents of the Syrian regime make. And I think there are three main moves. One of them is that the Syrian regime is pro-resistance, specifically Hezbollah. And given the fact that Hezbollah, after 2006, has gained popularity and respect in the Arab world, and the fact that Hezbollah has been, and its media outlets have been supporting the Syrian regime, many see see it through the eyes of Hezbollah and its media, specifically since Al Jazeera overdid it in many occasions in a way that it made it discredited, or at least less credible than it used to be in the eyes of many. The second is a Marxist kind of argument in which the world is divided into two different contradictions. One of them, some of them are secondary contradictions, and other of them are primary contradictions. So the primary contradiction is between the imperialism and its enemies. Syria happens to be, according to this logic, is an enemy of imperialism. Of course, what you said completely undermines this logic, because Syria was part of the war on terror and was torturing people for the U.S. Purpose. And I also mentioned that Syria was part of the troubles that the PLO had, and I can add also that Syria was part of the destruction of the left in Lebanon, and they assassinated the respected leader of the left, being Kamal Jumblat. But here the idea, the death of people becomes just a small detail in a world struggle between imperialism and its enemies. The third element, I think, is a sectarian element, which is mostly Christians, that is non-Muslims who are afraid of what democracy will bring. So they are more happy with a secular dictatorship rather than with a Sunni Saudi-like regime, which they fear. So I think these are the three main discursive moves, motivations, ideological blindness that leads many people to support what's happening. But of course, we need to remember that the media has factually, that is, the facts that you subscribe to are largely what I subscribe to, but I don't think that many on the ground see the factual picture in this way. Specifically that we cannot deny that there is, Syria has become a fair game. And the New York Times in the first pages discusses that the CIA or the different intelligence have been, or Saudi Arabia, Saudi money and Qatari money. So this is part of the picture. It doesn't change my overall view that there should be a change in the regime, but they have been using this and exaggerating it in many ways in order to justify their positions.
Thanks, Nimer. I'm going to invite Professor, well, I think there's two questions so far, so I can collect those questions and I'll give each of the panelists maybe 1 minute or 2 minutes to respond. So if you want to go ahead.
Oh yeah, just a question for May. I wanted to push you a little bit on the question that you got earlier, because I'm not sure. I mean, I guess the problem, if you try to distinguish on substance rather than form, I mean, it seems to me that ultimately, once you open the door for the use of volunteer violence, particularly in Middle Eastern societies, the way they're currently composed, you do create an opportunity for these sort of mutatawwa'in, volunteer organizations, to sort of spread. And it's hard for me to see how a distinction on substance is exactly going to work. That is to say, either you invoke the state and you say, well, you disarm these people, but don't disarm those people. But at that point, you've effectively given the state monopoly on violence. It's just conferred particular organizations, which is exactly what the Saudi government does with the Mutatawa'in. Or you create some sort of situation in which there's a great deal of internal civil violence that might be committed by groups against another. And I'm not sure how exactly that works out, or if it necessarily works out in favor of the leftist groups that you sort of favor. So I'm wondering how you sort of imagine that dynamic working itself out once you distinguish form and substance.
And Faisal, do you still have a question, or? Okay.
Actually, I'm assuming you were thinking of, for example, the Black Bloc, which is explicitly using, challenging the state's monopoly of violence. Again, part of my focus on these assemblages is not necessarily to say, like, I don't want to kind of emphasize, for example, the size of a group like a Black Bloc. As we know, like, it's actually a small group. But it's interesting that all these forms are arising and challenging some of the state's central functions, be it the monopoly of violence or even policing. Like, I think the group of Operation Anti-Sexual Harassment, I think, is quite interesting, because they actually, police the demonstrations, identify harassment cases, and bring the victim out and report it to the public through these videos, etc. And I think it's interesting. It's an interesting. There's an interesting commonality between these groups. With regards to the monopoly of violence, I think, like, right now, there's been a strike by the police in Egypt, and there's all sorts of, like, crazy ideas. Like, there was going to be a draft legislation on getting private companies, kind of like Blackwater, but to have kind of arrest powers, which is, of course, completely insane. And again, how do you kind of draw the line there? I mean, it's a private company, so that's a big difference. But again, like, this idea of giving authority to use violence or arrest outside of the space of the state. And I think the way to and also another example, before I forget, is just this morning there's another proposal by the Freedom Justice Party to write a legislation on having sort of making the neighborhood committees private militias, sort of like giving them arms and having a certain agreement with the government. So you find the state kind of trying to renegotiate these spaces. Like, they're kind of confused how to deal with them. They want to co-opt them, and hence some of them, they were forced to go under the law on NGOs, for example, by becoming an NGO. Those that they weren't able to co-opt said, well, maybe you could be our, this didn't happen, but this is some of the proposals of the Freedom Justice Party. So I think, like, the way to look at it is, I mean, it's difficult to kind of navigate, as you said, like, when you open it up to the substance of it, when it's not only the form. But I think the separation of the two is almost, like, impossible in this case. And having, like, a strict guideline of when to include this and when to include that, I don't think would be particularly helpful. I think the way I looked at it is, like, there's all these interesting clusters forming that have a very similar outlook towards the state.
Since there are no more questions, I would like to close this panel. I want to thank all the panelists and invite Mazen to close the conference. Thanks, everyone.
Just want to say a very brief comment. We started earlier today with a comment by Professor Falk when he said that one of the points that make the discussion about the Arab Spring or the revolutions relevant is that it brings back the relevance of politics. And this has been the recurring theme throughout the panels that we've seen today. We saw it very clearly in the first panel when we discussed the judiciary, the role of the judiciary, the role of legal theory and legal theorists. We saw it clearly in the second panel when we discussed political Islam, also the different outcomes after a revolution. And we saw it now very clearly, especially with the debate between Professor Alnasseri and Dr. Nimer Sultany on the role of law and the role of private property. So this, I guess, will leave with a note on the question, is it possible to study law without studying the social and political and geopolitical context? And thank you here, and I also want to thank our sponsors, the Office of the Dean of Osgoode Hall Law School, the Nathanson Center, and the Critical Research Lab in Law and Society. Thank you.